Hello everyone, it's day 60 and today I have 2nd May 2024 Indian Express newspaper and there are two important articles over the explained page as usual and there I find another important article on the page in between. It was about the DRDO testing some missile, so we'll see that article also, but let us quickly read this article, which is about the challenge and necessity of balance in use of fertilizer. So balanced in fertilization, that is discouraging farmers from applying too much urea, diammonium phosphate, or or muriate of potash, which have only primary nutrients in high concentration, is likely to be a key policy goal for the new government that takes over the conclusion of the Lok Sabha election. Urea consumption hit a record 35.8 million tons in the fiscal ended March 2024, 16.9% higher than the 30.6 metric ton in 2013 to 2014. The year before the Narendra Modi government came to power, the consumption of this fertilizer containing 46% nitrogen fell during 2016-17 and 2017-18, which was attributed to the mandatory coating of all urea with neem oil from May 2015. But the consumption of urea has only gone up during the last 6 years. So, nutrient based subsidy, let us see what nutrient based subsidy is about. Fertilizers containing nutrients and that are necessary for plant growth and grain yields. Balanced fertilization means supplying primary, that is the phosphorus, potassium, and K, phosphorus, potassium, nitrogen, phosphorus, and potassium. Secondaries, that is sulfur, calcium, and magnesium, and micro iron, zinc, copper, manganese, boron, and molybdenum. Nutrients in right proportion based on the soil type and crop requirements. In April 2010, the UPA government introduced the nutrient-based subsidy, under which a per kg subsidy was fixed for NPK and S. The idea was to wean away farmers from urea DAP, that is 18% nitrogen, 46% potassium content, and MOP, that is 60% potassium, and in favor of complex fertilizers containing NPK, S, and other nutrients in balanced proportion with lower concentration. Between 2009 to 2010 and 2011 to 12, DAP and MOP consumption declined, and that of NPKS complexes and single superphosphate, that is 16% and 11% sulfur, rose. But the NBS failed because it included nutrient-based subsidy. Failed because it excluded urea, with its maximum retail price being controlled and raised by the total of just 16.5% from 4830 to 5628 per ton. Post the introduction of NBS, urea consumption increased through the 10 years each of the UP and Modi government. So price hierarchy challenge. The last couple of years have been even non-urea fertilizer being brought under price control, first informally and then formally since January 2024. According to industry sources, the restoration of controls has worsened nutrient imbalances. The current MRP of DAP at rupees 1350 per 50 kg bag is below rupees 1470 for the 10 20 10 is to 26 to 26 to 0, and 12 is to 32 is to 16 is to 0 NPKs complex fertilizers, notwithstanding their lower N and P content. Even 20 is to 20 is to 0 is to 13, which accounted for nearly 5.4 metric ton out of the total 11.1 metric ton of NPKs complexes consumed in 2023 to 24, is retailing at rupees 1200 to 1225 per bag, only marginally lower than the DAP. So DAP has thus become the new urea, with farmers inclined to over apply both. On the other hand, MOP's MRP of rupees 1650 per bag incentivize neither farmers to apply directly nor company to incorporate it into complexes. The most widely consumed complex fertilizer, 20 is to 20 is to 0 is to 13, contains no potassium, and that isn't good. Potassium boosts immunity against pest and disease as well as uptake of nitrogen, a source said. So sources said an immediate challenge is to ensure proper price hierarchy among non-urea fertilizers. This would mean pricing DAP the highest, MOP lowest, and complexes in between. DAP use should be restricted only to rice and wheat. Other crops can meet their P requirement through complexes and SSP. So, what are the opportunities for India? India is heavily import dependent in fertilizers, and high global prices add to both foreign exchange outgo and the government's subsidy burden. Landed prices of imported urea, DAP, and MOP have fallen to around $340 and 520 to $525 and $319 per ton respectively, from corresponding recent record of 900 to $1,000 in November to January 2021 to 2022, 950 to $960 in July 2022, and $950 till March 2023. Even prices of phosphoric acid, a DAP manufacturing output, are drawn to $948 per ton from $1,715 levels of July September 2022. The cooling of international prices give some flexibility to the next government to rationalize MRPs of fertilizers and promote balanced plant nutrition. This could involve bringing urea under NBS and mitigating the impact of a significant hike in MRP by increasing the subsidy rates on the nutrients. So that was about the use of fertilizer and nutrient based subsidy in the fertilizer. So let us come to the another important article, which is regarding the article 31C. So it was about the private property. So let us see what this article is going to say. While hearing a case about private property, Supreme Court has asked whether Article 31C, a fundamental right, still exists. So what is this article? When what was it introduced in the Constitution? What has been its legal journey? So let us see. So during the ongoing hearing in the Supreme Court to decide whether the government can acquire and redistribute private property, a nine-judge constitution bench led by Chief Justice of India D.Y. Chandrachud asked a question of radical constitutional consequence: does Article 31C still exist? So Article 31C of the Constitution protects laws that are enacted to ensure that material resources of the community are distributed to serve the common good. Article 39 clause B, and that wealth and means of production are not concentrated to the common detriment. That is Article 39 clause C. Article 39 of the Constitution lists certain directive principles of state policy which are meant to be guiding principle for the enactment of laws but are not directly enforceable in the court of law. As per Article 31 clause C, 31C, these particular directives principle, Article 39 clause B and 39C, can not be challenged by invoking the right to equality, that is Article 14, or the right under Article 19, freedom of speech, right to assemble peacefully, etc. So why is this continued existence of Article 31 clause C itself now under question? And how is this article of the Constitution related to the question of private property that the court is considering? So, introduction of Article 31C. Article 31C was introduced by the 25th Amendment. By the 25th Amendment Act 1971, and the law essentially framed to ring fence an adverse court ruling in the bank nationalization case in 1970. So, Article 31 Clause C says that 31C says no law giving effect to policy of the state towards securing the principles specified in Clause B or C of 39B shall be deemed to be void on the ground that it is inconsistent with or takes away or abridges any of the rights conferred by Article 14, Article 19, or Article 13. And no law containing a declaration that it is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy. So, journey of Article 31C. The 25th Amendment Act was challenged in the seminal Keshwanand Bharti case. 25th Amendment Act in the Keshwanand Bharti case 1973 in which 13 judges held by a narrow 7-6 majority that the Constitution has a basic structure and that cannot be altered even by a constitutional amendment. As a part of this verdict, the court struck down the last portion of the 31C, the part that states and no law containing a declaration that it is for giving effect to such policy shall be called in question in any court and on the ground that it does not give effect to such policy. The Keshwanand ruling allowed land reform laws that were under challenge, but stated that even laws that are protected by Article 31C must pass the basic structure test, even if such laws can bypass Article 14 and 19. Simply put, the court ruled that the land reforms did not did not violate the basic structure of the Constitution, but for all future examination, the test would apply. In 1976, Parliament enacted the 42nd Amendment Act, in which expanded the protection under Article 31C to all or any of the principles laid down, all of the, any of the or any of the principle laid down in the Part 4 of the Constitution. As a result, every single directive principle, Article 31, 36 to 51, was protected from challenges under Article 14 and 19 of the Constitution. So the statement of object of reason for the amendment stated that it was meant to give precedence to the directive principle over those fundamental rights which have been allowed to be relied upon to frustrate socio-economic reforms for implementing the directive principles. In 1980, in its judgment in Minerva Mills case versus Union of India, the Supreme Court struck down the clause 4 and 5 of this amendment. The five-judge bench held that Parliament's power to amend the Constitution was limited. It could not be used to remove these limitations and grant itself unlimited and absolute powers of amendment. However, this ruling birthed a conundrum that Apex Court must now address. So, by striking down part of the 25th Amendment, did the court strike down the Article 31C as a whole, or did it restore the post Keshavan Bharati position wherein Article 39 Clause B and C remained protected? So, ongoing case in the top court. The court is hearing a challenge to Chapter 8A of the Maharashtra Housing and Area Development Act 1976. This chapter, introduced by an amendment in 1986, allows the government to acquire seized properties in Mumbai at the request of the occupants, citing the obligation under Article 39B of the Constitution to distribute material resources of the community to subserve the common good. Occupants of seized properties, old old dilapidated buildings that houses poor tenants despite becoming increasingly unsafe, are required to pay cess to the Mumbai Building Repair and Reconstruction Board, which oversees repair and restoration projects. So in 1991, the Property Owner Association in Mumbai challenged the 1986 amendment at the Bombay High Court, but the High Court upheld the amendment, citing the protection granted by the Article 31 Clause C to laws enacted in the furtherance of the Article 39B. This decision was appealed at the Supreme Court in December 1992, where the question eventually became whether the material resources of the community under Article 39 Clause B included private resources such as the seized properties. So, arguments in the Supreme Court. When the hearing finally began on the first day, April 23, the nine-judge bench seemed to agree with the center's submission that the case should be restricted to interpreting Article 39B. CJI Chandrachud said, "It's very clear that the ambit of the reference to nine judges is squarely only on the content of the Article 39 Clause B, according to the reporting by the Supreme Court observer. However, the very next day, the bench stated that the question of whether Article 31C still lives following the Minerva Mills decision has to be decided to avoid constitutional uncertainty." So, senior advocate Zal Andhyar Juna, appearing for the petitioners, argued that the original version of Article 31C was substituted with the expanded version provided in the 42nd Amendment. So, this Andhya Purjana argued means the older version of the provision ceased to exist once the amendment came into force. Therefore, when this new Article 31C was struck down in Minerva Mills case, the older version would not automatically be revived. On the other hand, Solicitor General Tushar Mehta, appearing for the centre, argued that the doctrine of revival must apply in this case, and the post Keshavanand Bharati position on Article 31C must be restored. To explain the doctrine and justify its application, Mehta relied on Justice Kurian Joseph's observation in the case where the court struck down the constitution, that is 99th Amendment Act, which was regarding the National Judicial Appointment Commission. So Justice Joseph held that the old collegium system for appointment of judges would be revived once the 99th Amendment, which introduced the National Judicial Appointment Commission, was struck down. He observed, once the process of substitution and insertion by way of constitutional amendment is itself held to be bad and impermissible, and pre-amended provisions automatically resurface and revive, that alone can be reasonably inferential conclusion. So this was all about important articles in today's newspaper. There was one important article regarding the DRDO, which has successfully tested the missile-assisted torpedo system. So that we need to know. So I think that's all from today's newspaper, and no more important article in today's newspaper. So we'll meet with another important article. So only few days are left for the challenge to be completed. It is day 60 and 15 days are left. So we are on our target. So we'll meet tomorrow. Till then,